So my role on the panel is to basically give you a quick overview, bring us back up to speed on how we got to where we are now, and where we might be going. And then I'll get out of the way and we'll hear some expertise. So first question, are people with mental illnesses currently eligible for MAID, medical aid in dying? Yes, they are eligible, but only if they meet the same eligibility criteria that apply generally. One of which is that natural death be reasonably foreseeable, and of course capacity as well applies to everyone. And so because of that middle criterion, natural death being reasonably foreseeable, relatively few people who solely have a psychiatric condition will qualify. There's a few cases where you might imagine they would qualify, but in general not. There is one case that we know of from Ontario in which a very elderly woman with osteoarthritis and frailty was said to qualify as well. In that case, not because of her osteoarthritis, the condition that was causing the suffering, but because of her age. So there's another potential possibility that very elderly people with a mental illness that's causing suffering would also be eligible currently under the authority of the AB case in Ontario. To my knowledge, that hasn't been tested, but it's possible. One thing I did want to mention that has been going on as well, which is useful to know about, is in the last couple of years, there have been a number of people ineligible for medical aid in dying because they don't have a condition bringing a natural death into reasonable foreseeability, who have chosen to refuse food and water to deteriorate into a condition that then makes their natural death reasonably foreseeable. And several cases in Quebec, a recent one last year in BC raised the question, and the coroner sent a request to the medical college about a particular case for clarification on whether voluntarily stopping eating and drinking qualified as a natural death. In other words, would a natural death be reasonably foreseeable if the death was brought about, or the risk of death was brought about by stopping food and water? And the answer was, well, yes. People have a right to refuse treatment, including our nutrition and hydration, and that would qualify as a natural death. So I bring this up only as part of the full picture of the eligibility criteria around people currently who have solely a mental illness. So I would say that clinicians should be thinking in the back of their head about the issues around people who choose to become eligible in that way. Okay, so how did we get here? All of you know no doubt about the Carter case in 2015, and this one essentially ruled the criminal code provisions that prevented assisted dying and euthanasia unconstitutional, but solely for people who are competent adults who give clear consent and suffer a grievous and irremediable medical condition. There was a question, does this include psychiatric conditions? There was some wording in the Carter case which suggested they didn't have that in contemplation, although the criteria as set out didn't exclude it. And between that period between the striking down of the criminal code and the subsequent introduction of federal legislation, there was a case in British Columbia raising that very question. A woman who had a conversion disorder, a severe conversion disorder causing pain and movement problems, which is understood as a psychiatric in origin, applied for medical aid in dying, and the Court of Appeal considered whether she qualified and said yes. So at least the interpretation of one appellate court was that people with a solely psychiatric condition did qualify under the Carter criteria. Now, the Carter criteria lasted for a bit, during which period people who wanted medical aid in dying went and got judicial approval. That was the process until we had Bill C-14. So the federal legislation came in, and I should mention, because we have someone from Quebec, that Quebec was way ahead of this with their own legislation. So that also is a piece of what's going on in this puzzle, but I'm tracing our federal legislation for now. So the federal legislation came about, and you'll see, added a few things. So same thing, capable, voluntary informed consent, all the same, but started to add a few details to grievous and irremediable condition that hadn't been present in the Supreme Court judgment. And in particular, natural death has become reasonably foreseeable, advanced state of decline, and serious and incurable. So what you essentially see in terms of eligibility was Supreme Court, arguably, as I've laid out to you what we think the Supreme Court ruling meant, you had a scope of eligibility, the big circle. The federal law made it a bit narrower, and the Quebec law is narrower still, because it requires end of life. Whereas the federal legislation, natural death has become reasonably foreseeable, no one, to be honest, knows exactly what that means, but it seems to be a little bit more capacious than end of life. So where are we going? So immediately after the enactment of the federal legislation, there was a challenge launched, this was like a matter of a week afterward in 2016, by a young woman in BC challenging the federal legislation. She's someone who has a degenerative neuromuscular condition, and she said it was discriminatory and contrary to Section 7 and 15 that people in her condition were excluded. And so that is working its way through the process. A little bit later, two claimants in Quebec, Truchon and Bladu, brought a similar challenge not just to the federal legislation, but also to the Quebec legislation. And you will have seen perhaps in the news that arguments were made this winter. So we're waiting to see what happens, because it's very important to keep this in mind. If these courts choose to strike down these requirements of end of life or natural death reasonably foreseeable, it opens up potentially eligibility for people with sole underlying medical condition being that of mental disorder. So where should we be going? Well, I see the four potential options. One, the law stays sort of the way the law is, status quo, in which you have limited eligibility for MAID, sole underlying medical condition being mental disorder. Potential eligibility in the context of frail elderly and voluntary stopping eating and drinking, so those will have to be dealt with. You could also choose to roll eligibility back and say, well, actually we're going to exclude current eligibility exclude some of the people currently eligible by reforming law. That's possible as well. One would have to investigate the constitutionality of something that targets one class of people precisely in that way. You could also expand eligibility for only physical conditions that are non-terminal. Again, I would question how we would have to do some constitutional assessment about that distinction and its constitutionality. Or you could expand eligibility for all non-terminal conditions. In other words, not distinguishing between physical and mental disability, but opening up eligibility for that broad group, which raises the question, well, would you apply the same eligibility criteria in that context, or would you perhaps apply a different one? So it being otherwise not a sole choice between no eligibility and some eligibility, but eligibility on maybe different terms with different processes. And some of the possibilities one might consider, should there be a different eligibility threshold? Addressing capacity in some way that's different for non-terminal conditions. Should questions about the stability of the request be raised and require sort of a longer period of stable desire for MAID? Should we do something different with treatment history and leave room for the physician to weigh in on whether reasonable treatments have been exhausted? This would be contrary to the general thrust of the law, which leaves to the capable person the choice of whether to take treatment or not, but it's a question. Interdisciplinary independent assessments is something that could be applied in some categories where you think that there's a whole range of other non-medical services that could be brought to bear to reduce suffering. And again, you could look for different procedures involving judges in the non-terminal cases, perhaps as a safety mechanism. So there's a range of other possibilities, and I put that out there without any further deep discussion, but just to make sure we have a whole range of possibilities of absolute exclusion, absolute inclusion, or something in the middle, a inclusion but on different, more restricted terms. So I'm going to get out of the way now and hand it over to my colleague Dr. Mona Gupta, who will be taking over after me.
If you want to get a seat, there are some seats here, and there are some seats in the various rows.
All right.
So if you've got an empty seat next to them, and I'm looking at you, could just take a seat.
I think we might wait to have discussion after all three, unless there's more clarification about what Gupta's.
I did.
Oh, okay, go ahead.
I'm having trouble understanding the difference between number 2 and number 3 in your proposal. The exclusion of all mental illnesses versus physical non-terminal conditions. Those look the same to me.
Let me go back and see what I said. Number 2 and number 3.
Yeah.
I was suggesting that we might, one possibility would be to change the rule now to explicitly exclude people with mental illness, because it's not currently That's not the law at present.
Right.
And the third instead would be an expansion of eligibility, but only, it would leave in place those people with a mental condition who are currently eligible, but it would expand eligibility, but only for physical non-terminal conditions.
Okay.
Okay?
Right.
Yep.
Okay, great.
There aren't 2 seats here. So it's,
doesn't want to attach, so I'll just carry it around with me as I move. Thanks very much to the organizers, particularly Jennifer and Colleen, for the kind invitation to join them here today at this panel. Looking forward to a discussion, a rich discussion afterwards. I want to say a couple of things just by way of general introduction. The first is, although we are repeatedly going to talk about mental illness and mental disorder, I think it is, these two terms or expressions resist generalization in the same way that if we had this same topic and said as access to MAE for persons with physical illness, we wouldn't be able to make simple generalizations. So I think even though we're going to keep using those terms in the discussion, that will be the time for us to be more specific about what we're talking about, what kinds of cases and situations we're talking about exactly. The second comment I want to make is that I'm going to flip back and forth between the Quebec law and the federal law for 2 reasons. One, that in Quebec, we are in the interesting situation where both laws are valid and apply. So where they are slightly different or contradict each other, we have to figure that out. So the fact is that we cannot, although we practice under the Quebec law, we have to take into consideration that both laws are valid and apply. The second reason why I want to talk about Quebec and why I'll make reference to Quebec here and there is simply that, and many of you may already know this, that the Quebec law was not a response to the Carter decision. It was passed in the legislature before Carter was decided. So it came about through the province's exercise of its competence in health and has nothing to do with the criminal code. So I'm not going to get into detail here because Professor Chandler has already explained all of this to you. I merely want to point out that the phrase that she was alluding to in the Carter judgment is this one here on the third point. I'll put this in just the bit about psychiatric disorders in bold, where the decision takes the trouble to say that the reasons given in the document, in the decision, don't apply to minors or persons with psychiatric disorders. But as she points out, the criteria that are then listed in the decision don't say anything about psychiatric disorders. What this means, I don't know. I'll leave it to the legal scholars to explain how these two things can be reconciled. But as a lay person reading that, it seems to me that what was said in that decision wasn't intended to apply to people with psychiatric disorders, but what that really means in practice, I'm not sure. So I want to start by saying, I don't think this is controversial, that the policy objective, certainly of the Quebec law, and perhaps less so of the federal law, was to ensure that all means possible for relieving suffering at the end of life were available. So following this logic then, I think we need to start with the question about whether medical aid in dying is an appropriate act outside of the context of end of life for anyone, regardless of what their condition is. And so the reason why I want to say that up front is because I want to take all of those considerations about people with chronic diseases more generally off the table for the purposes of our discussion and our limited time and focus on the specificity of mental illness. And I do this because I think it's inconceivable that we would expand access to people with mental disorders, but say anyone with a chronic physical disorder is still excluded. So I think inevitably, if there's going to be expansion, it's going to include all people with chronic disorders, but our task today is to explore the specificity of mental illness. So essentially, there are a number of issues that have proved to be controversial in talking about making medical aid in dying accessible to people for whom their mental disorder is the reason motivating their request. And I'm going to go through each one of these in turn. Here we go. Okay, so essentially with respect to suicide and suicide prevention, prior to the two laws, the suicide prevention perspective was that we would simply try to prevent any person who wanted to bring an end to their life from doing so, including those people who are at the end of life, all right? We'll bracket for a moment the marginal practices that were occurring really on an idiosyncratic and individual basis of hastening death amongst people who were really in the last hours or days of life. But apart from them, suicide prevention applied to the entire population regardless of their medical status. The advent of the two laws means that we no longer do this. And in some cases, we actually help people to bring an end to their lives. And of course, who we help is laid out by the MAID eligibility criteria. In theory, from a suicide prevention point of view, everybody else should continue to be prevented. These are the Quebec criteria here, these are the federal criteria, and I've removed end of life or natural death reasonably foreseeable for the purposes of our discussion. We can imagine that there are cases that fall into that overlap zone between the criteria. And again, this is the criteria in Quebec for involuntary hospitalization for a suicidal person, a person whose mental state represents a danger to themselves. We can imagine that there are people who represent a danger to themselves by virtue of asking for medical aid and dying, and yet they also fulfill these criteria. So they're somewhere here in this overlap zone. What do we do with those people? Are we preventing them? Are we helping them to die, or are we neutral about their fate? So that's a question that's been raised. Did you want to ask a question?
Do any of those points touch on the exhaustion of all possible courses of therapy?
Currently, the criteria do not require anyone to take any treatment that they competently refuse. Okay? And that's for any condition. The second issue that has proved to be contentious is that about capacity. And it's contentious for a variety of reasons that we'll review quickly now. So the first is to note that despite our linguistic usage, where we talk about a person as being capable or as having capacity, capacity is not the property of a person, okay? It's not like the color of your eyes or the shape of your nose. Capacity is merely a normative threshold that society sets for clinical decision making. We decide that you have to have these kinds of abilities in order to be entitled to make those kinds of decisions. Whether or not you have those abilities is a separate question, but it's the combination of the abilities you have and this threshold that determine capacity. So the existing criteria that we use and that are defined in law, in some cases by policy, and others in Quebec, it's the Collège des Médecins that provides regulatory guidance to physicians about how to evaluate capacity. They tend to be focused on cognitive abilities. Your ability to understand, your ability to reason, your ability to appreciate, your ability to evidence choice. And what we find in the literature is that when patients with mental disorders are evaluated for their capacity, that we see a lot of variability in results, particularly for high stakes decisions. So the question is, A, are people with mental disorders generally speaking capable? That one's easier, and the answer is yes, except for certain conditions in certain circumstances. The harder question is, what about the fact that we see all this variability in evaluation, that 2, 3, 4, 5 psychiatrists could evaluate the same person in the same circumstances and arrive at conflicting results? What do we make of that? Again, I think that's an open question. How much disagreement is too much disagreement? That's a discussion for us to have after. A third issue which has proven to be controversial in the case of mental disorder, and this is perhaps specific to mental disorder, is that of prognostication. So as you may know, diagnosis in psychiatry is done on the basis of syndromal characteristics. You have a diagnostic category, say major depressive disorder. There are a number of symptoms that a person might have in order to have that diagnosis. But if you had 10 people, all who had that diagnosis, they may not share the same symptoms. You must have 5 of the 9 symptoms in the category, and depending on the diagnostic category, it's a different number. So let's say for major depression, number 1 might have a certain 5. Person number 2 might share 2 but have 3 different ones. Person number 3 might share 4 of the first one but have a 5th different one, and 2 others. So you have a great clinical heterogeneity within single diagnostic groups. And that means that prognostication by diagnosis is difficult because you cannot meaningfully speak in terms of prognosis about a category of people when you're talking about the individual, because the destiny of that individual versus that of the group cannot be connected together. And we've had many surprises in the course of the last 50 years in psychiatry, conditions that we thought were uniformly conditions leading to decline and poor outcome, or lifelong, being affected in a lifelong way. It's turned out not to be the case in specific individuals or under specific circumstances. So the idea that we can accurately say what's coming in the future, in other words, that a person is in an advanced state of irreversible decline, is much more difficult for mental disorder, and in some cases not possible. The variable that influences our ability to make good predictions is time. So your ability at time 0 is quite poor. Your ability at time 30 years is better. But it's a very big difference compared to our ability to prognosticate on the basis of diagnosis for other medical conditions. That's not to say there aren't surprises in other areas of medicine as well. But when somebody is diagnosed with stage 4 ovarian cancer, what's going to happen to them in probabilistic terms is a lot easier to define than when somebody is diagnosed with major depressive disorder. Now this is a criteria for Canada. It's not a criterion in Quebec, but it's a condition for carrying out the act. In Canada, the language is that the request is voluntary. In Quebec, is that it's freely made. And people have argued that certain characteristics of mental illness may compromise voluntariness in some cases. Impulsivity, for example, distorted thinking or feeling, psychosis, suicidality itself, which can be a symptom of a mental disorder. And just to draw the distinction with capacity, for example, somebody might be capable, that is to say they fulfill the legal criteria that define capacity, but their impulsivity may make a request non-voluntary. So conjure up in mind the chronic gambler, who is very able to tell you the risks and benefits of his behavior, of treatment, of refusing treatment, but simply cannot control the urge to go and gamble, even to his own self-destruction. So there is a difference between the idea of legal capacity and a request being voluntary or freely made. And I think we could make the same analogy with somebody who is psychotic, for example, who may well believe that the university has been taken over by aliens and that they are running about implanting people's minds with computer chips, but that they understand the risks and benefits of the treatment that you're proposing, and that it might even take these ideas away, but that doesn't change the fact that this is really happening. Okay? And finally, another concern, I think, with respect to whether a request is voluntary or freely made, actually concerns social circumstances in which people live and not the characteristics of their condition themselves. And that is the fact that mental illness is strongly correlated with poor social conditions, including poverty, social marginalization, which may influence and even cause suffering that might motivate a request for medical aid and dying. So what do we do about that? How do we figure that into an analysis about whether access should be expanded? So it leaves us with the question, having reviewed some of these controversial areas, on what basis could we exclude categorically persons with mental illness? So yes, it may be difficult or even impossible in certain cases to establish capacity, prognosis, or voluntariness. Is this sufficient to justify a category exclusion? I mean, that is, I think, a legal and an ethical question for us to discuss. I want to bring us back to another way of thinking about the controversies, which is that some folks will say, but hang on a minute, this isn't just about capacity, prognosis, and voluntariness. I mean, after all, aren't these folks really just suicidal? And wouldn't providing aid to them be a form of state-facilitated suicide? So I spent a lot of time thinking about this question, and I'm not really sure what the question means, actually. And I think that's going to be one of the things that will be interesting for us to talk about. What does it mean to say that someone is suicidal beyond the idea that they're not capable, or that actually they could go on living for a long time and be well, or that their request is somehow not voluntary because they don't see that there are alternatives to help them in their difficulties? Does it mean something apart from that? Is it another way of saying that people have mental disorders, that leads to intense suffering, they want to end their lives, but they don't really want to die? So it's like a species of non-voluntariness. Whether we should prevent someone from trying to bring an end to his life turns on the question of whether ending one's life constitutes a harm to him. Is his mental state dangerous to himself? Or does it reflect an autonomous choice made in his own interest? And this in turn depends on the same three elements that can be difficult to establish: capacity, prognosis, and voluntariness. So in such cases, the question may not be, is the person capable or voluntary or in a state of decline, but are they capable enough? Are they voluntary enough to push them from the suicide part of the Venn diagram into the gray zone? And with that, I will hand it over to my colleague, Colleen.
Thank you.
Okay, so thank you Mona and Jen and Simon and Martine for getting it started. I'm just going to briefly talk about some of the comparative evidence that we reviewed as part of the panel that we all served on for the Canadian Academies looking at this particular question. And hopefully quickly move to the discussion. So one of the things that we did think about a great deal was what we could learn from other jurisdictions that have permitted medical aid in dying for those who are living with a mental illness alone, or mental disorder alone, I should say. And we weren't particularly focused, we excluded folks with dementia from our analysis here, so this was focused on people outside of that. And one of the things that we were very careful to consider was how can we learn from other countries? You can't just go country shopping for something that looks palatable and bring it back to Canada and expect it to work. So we were very sensitive to the particular context of Canada's particular legal system, Canada's particular healthcare system, Canada's, its Indigenous peoples, its geography. These all make comparisons. Comparisons can be odious, but on the other hand, we felt there was things that we can learn, and also that undoubtedly in upcoming constitutional challenges, that the courts would consider evidence from other countries to help it in the determination of where it will go. So we were, we were careful, but we did embark on this. And just as an example here, we had Jen mention the possibility of having multiple layers of review, for example, psychiatric review, before one conceivably could permit someone who is living with a mental disorder alone to access medical aid in dying, right? So that could be a safeguard one could imagine, that you may require, for example, 2 psychiatrists, not just a secondary review, to actually review the application to make sure that no one was being unduly pressured into seeking medical aid and dying, that they had capacity, etc. But that obviously in the Canadian context, perhaps not that obviously, but is quite a challenge from an accessibility perspective, because in many parts of Canada, access to a psychiatrist, just one psychiatrist, is extremely difficult. So unless there was some way through technology to achieve this, so it wouldn't be an in-person kind of meeting. So these are the sorts of things I think we have to really consider when we consider these kinds of safeguards, that if we were to permit this, how it would play out in Canada. So the first thing to note, I think, is that the countries I'm talking about, and which we focused on primarily in the evidence review, are the Netherlands and Belgium, for a variety of reasons. But this is where you see the ability to seek medical aid in dying for those living or suffering from a mental disorder alone. So they don't have a physical illness as well. They're primarily seeking it because of the suffering that they're experiencing from their mental disorder. So the Netherlands and Belgium. But I think it's important to note that there's a problem of small numbers here. So it's a very small number of total cases that we're looking at. 1 to 2% of all of the medical aid and dying cases are for people living with a mental disorder alone, seeking medical aid and dying. So because you have small numbers, it's quite difficult then to say anything hugely significant from the numbers involved. So 40 cases in the Netherlands and 83 cases in 83 cases in the Netherlands and 40 cases in Belgium. So with that caveat as well. I think what is also interesting is a different context for how the law has evolved in these countries as opposed to in Canada. And that too reflects, I think, the different legal context. So as I understand the evolution of medical aid and dying in the Netherlands, it really came about from professional practice. So the profession itself had decided that it would provide medical aid and dying, and it was supported subsequently by some early court cases. And the profession itself, the medical profession itself, developed the norms of practice of how they would approach this question, how they would review this question, the safeguards that they would put in. And then the legislation that is now in force in the Netherlands really reflects that professional stance. Whereas here, it has been more of a top-down approach from the Supreme Court ruling in Carter, and then everybody playing catch-up to some extent, with some caveats around Quebec in this regard being a more of a forerunner for other provinces. So I think that's a different kind of a context. So there's more of an established idea across the profession of psychiatry itself, across the medical profession, about how this will play out and the kinds of safeguards that are important. And we've had, I've heard a Dutch psychiatrist, for example, who participates in medical aid and dying, evincing some frustration really about how we approach this from his view, a very kind of legal perspective on these things as opposed to a medical perspective on these things. Okay, so this is the Dutch law, which, as I said, basically codifies professional practice. Says that it is legal for a physician to provide medical aid in dying if due care is followed. And due care requires that a physician be satisfied that the patient's request is voluntary and well considered, be satisfied that the patient's suffering is unbearable with no prospect of improvement, have informed the patient about his or her situation and prognosis. And then I put this in italics because I think this is very interesting compared to our approach. Have come to the conclusion together with the patient that there is no reasonable alternative to the patient's situation, and have consulted at least one other independent physician who must see the patient and give a written opinion. Now, with respect to that last piece, that independent consultation, it may be of interest to you that it's not necessary that there be agreement, right? Just that the physician providing MAID has actually done that consultation. The other physician may not agree, but the medical aid in dying can still proceed so long as the physician has taken that opinion into account. Under Canada's current medical aid in dying laws, two independent assessors must agree, right? So we have that safeguard. But we do not have this safeguard in D, have come to the conclusion together with the patient that there is no reasonable solution, reasonable kind of alternative. So the Belgium Act on Euthanasia is somewhat similar in that the physician who provides MAID does not commit a crime if the patient is in a medically futile condition of constant and unbearable physical or medical suffering that cannot be alleviated, resulting from a serious and incurable disorder caused by an illness or accident, with no reasonable treatment, alternative, or therapeutic perspectives. So again, it's more an objective assessment of whether this is actually the case and not from the individual's perspective. So as Jen has already alluded, and so has Mona, the difference for us is that in our law, and really reflecting our view of consent vis-a-vis medical treatments, that this is really up to the patient, right? Whether or not their suffering is unbearable and whether or not they are willing to take treatment. So if a cancer patient says, I don't want any more of these treatments, even though you may think they are good for me, and thus puts him or herself into a position where they can qualify for medical aid in dying, that's okay, right? If we were to expand medical aid in dying for those living with a mental disorder, and we still had this stance, then there would be the possibility that someone living with a mental disorder would say, well, by my own lights, I'm sick of this treatment regime, and I wish to seek medical aid in dying, even if eschewing the treatment puts them into that space of living with unbearable suffering. Right? So with the treatment, they may not be living with unbearable suffering. They eschew the treatment, then they're living with unbearable suffering. Then they may wish to access medical aid in dying. So this is I think, to me, a tricky part of how, if we wish to open it up to some extent, and we know that people living with mental suffering, it is as bad, if not worse, than physical suffering on many occasions, and that people after many years of TEMP treatment and psychiatric treatment, have felt that there are no options for them. So should they at that point be able to eschew the treatment and move forward? So how do we do that given our approach? So some questions, and our job in these reports was really just to marshal the evidence. We weren't. In fact, we were told very clearly, do not come up with an opinion. Nobody actually wanted our opinion, which is just as well, because it was quite a difficult task, just marshalling the evidence. So how important is the safeguard in the Dutch law and the Belgian law? So what we don't know is if that safeguard isn't in place, like how many individuals would be seeking medical aid in dying? Right, that's what we don't know. Because there are other safeguards in place, so we don't have a nice randomized controlled trial. We have one safeguard and without it, and then another one, you know what I mean? So we don't know for sure which one is doing the work in terms of keeping the numbers relatively low. So that's something we don't know yet. Would such a safeguard be appropriate in the Canadian context? Is it discriminatory to require those living with a medical disorder to submit themselves to treatments that they don't want prior to being able to avail themselves of medical aid in dying when we don't do that for the physically ill? We'll come to the end, okay? And then how long, if we say, well, people should be required to at least try treatment, how long is long enough before we say, okay, you've given it a good try, and the medical system really has nothing to help you here to alleviate your suffering. And then finally, would a safeguard be constitutionally permissible? So I'll just finish with this question, the charter issue, which is, will be litigated undoubtedly, and is, and to some extent already. If additional safeguards, from a charter perspective, this is a kind of question we have to ask ourselves, and balancing the rights of individuals with the policy goals of the government, or concerns that it may have when it brings in the safeguards, right? So if additional safeguards are added that apply to those only living with mental disorders, then to be justified, it needs to be demonstrated that they guard against risks that are not faced by those seeking aid with physical disorders. And so some of the issues that Mona raised about the difficulty with prognosis and instability of preferences and things like that, this is all important evidence that would have to be used to justify a safeguard if it was put in place by a government. And so differential treatment may be warranted due to the unique characteristics of such disorders, the ultimate decision making and perceptions and so forth. So it may be justified, but we have to produce all the evidence in a courtroom setting for the court to weigh back and forth to decide whether any particular safeguard is okay.